So it's the second week in January 2013, and I wanted to provide a casual video update to explain what I see happening out there in foreclosure world. I didn't plan this, but I'm wearing my shirt here from the American Civil Liberties Union, right there, proudly displaying my emblem, and in a sentiment that I think Americans need to adopt. This sentiment reflected here on the shirt reflects the growing distrust of government and institutions all across this country. It's a well-founded distrust, and frankly, about the only thing we have left anymore are attorneys who are willing to stand up and fight for consumers on their own, too, as this t-shirt says, sue the bastards. Now, I want to focus here specifically about two very disturbing developments that have taken place and have a national significance, and that is the two settlements that have been reached between our banks and institutions and the government that used to represent the people of the United States of America, but now who represent the banks and institutions. A few months ago, of course, we had the 49-state Attorney General settlement. That was a travesty in and of itself. Consumers were thrown under the bus for a few $100s, and now it's gotten worse out there in the state as a result of those settlements for consumers. And then just recently, here in the first week of January, the second settlement was announced, and that's the Federal Reserve Office of Comptroller and Currency settlement. Now, it's important to note that we don't know specifically what the terms of that settlement are, the so-called independent reviews that were being conducted and that originally were being reviewed and supervised of 14 different banks. Now, the settlement reports that only 10 of them have settled with the federal regulators, the Office of Comptroller and Currency, and the Federal Reserve. Keep in mind what was occurring here. Now, those two federal agencies, the Office of Comptroller and Currency and the Federal Reserve, were theoretically charged, or not theoretically, specifically charged with regulating and supervising the banks and institutions which are enumerated in the consent decrees and the agreements under which they were settling, and had agreed to enter into settlement agreements whereby they would be reviewing all of their individual practices and procedures that resulted in all the fraud that's choking up our courtrooms all across this country. Now, as part of that foreclosure settlement and the agreements that were reached between the institutions, they agreed that they would hire independent consultants and experts who would go in and would review the files that those individual banks, institutions, and servicers had been clogging our courtrooms, polluting our courtrooms all across this country. And so, as part of the settlements that they reached way back when, they agreed to enter into this process whereby auditors and independent reviewers would go in and review these files. And so, they hired these inside groups. They called them independent, but they weren't really independent at all. These were companies, corporations that had close ties with the banks that they were supposedly reviewing. To me, the most egregious and grotesque example is that of PricewaterhouseCoopers, the corporation that was retained to review the GMAC Homecoming's financial files. Now, I was up in New York City during the GMAC bankruptcy hearings, and I was blown away because we're sitting in a room with, 100 lawyers in there, and immediately before the hearing that I was there for, which was a request to appoint a borrowers committee, a very innocuous thing, something that was very equitable and fair, and it simply said that, you've got hundreds of thousands of consumers all across this country who are going to be impacted by the GMAC bankruptcy, and we asserted that consumers had a right to participate in those federal bankruptcy proceedings just to provide input, guidance, suggestion, and to have some input over what was occurring in their name in the context of this bankruptcy. Now, GMAC and a couple of the other creditors filed responses, and one of the primary arguments that they had against appointing this bankruptcy committee was that the GMAC and Homecomings were already under supervision by the OCC and the Federal Reserve primarily as part of this settlement, this agreement that they had reached, and as asserted in their memorandum, any kind of supervision that was necessary for consumers would occur during then, making the borrowers committee unnecessary. So a question that I present, when the very reasonable request that borrowers be represented there was rejected, part of the reason for that rejection was that they said that the OCC was going to be reviewing this. Now, Now that that's been shut down and scuttled, should we revisit the BMAC Bankruptcy Borrowers Committee petition because in fact there's going to be no supervision and no further review of that? Of course, we know the answer to that question. Nothing's going to happen. Consumers once again got kicked in the teeth. But back to the larger impact of the OCC Federal Reserve settlement and the 49 state AG settlement. You know, when the 49 state AG settlement was announced several months ago, of course, all the national press and our local press picked up on the propaganda that was put out by the banks and institutions, and all we read about was the headline, which said record settlement, $25 billion worth of consumer relief that's going out across the country. And that hit the big five: Bank of America, Wells Fargo, Citi Mortgage, GMAC, and you know, nobody bothered to dig deep into the settlements to recognize that, you know, very little, if anything, was coming out of the banks or institutions themselves, and the great majority of the settlement was coming in the form of write-offs of debt that was never going to get collected anyway. And the reporting that's come out since then, of course, doesn't have nearly the intensity and nearly the attention that's attracted by that initial settlement. So you get these big headlines: $25 billion settlement, banks settling, consumer relief, et cetera, and then now we hear months on, and we're not seeing any additional reporting to show that settlement really didn't do much for consumers at all, except write-offs of debt that had already long been written off. Now, there's an interesting side component of that, and that is consumers are going to be getting hit with 1099-C tax liability as a result of that waiver of debt, that deficiency. And, you know, for many of those consumers who weren't being hounded on that debt at all, and that debt was zombie debt that wasn't going to be picked up or pursued by anybody, the fact that now they're being chased by the IRS for this debt relief that they got is a truly disturbing side effect of a settlement that nobody talked about and not a single person in the press reported about. The other thing is, no one is going to report when the number isn't reached of $25 billion. Nobody's going to follow up to that settlement agreement to say that, in fact, the banks didn't pay anywhere near $25 billion. They didn't even get close to it. But that's a side impact, and that really doesn't have much impact on what we face here on the ground level. What you saw happen immediately after announcement of the settlement was a fairly dramatic uptick in the prosecution of foreclosure cases, hearings being set, summary judgment, sales being set, those things going forward. And, of course, nobody talked about that as a side impact of the settlement agreements. And in the press releases, in the statements of the regulators, the banks and institutions, and the government officials that asserted to be working on behalf of consumers, there wasn't a single one of them that said that once we ink this deal, what's going to happen is foreclosure is going to be moving forward much more quickly. And in fact, that's what we saw happen immediately after that settlement. Foreclosures being set, sales being set, consumers getting thrown out into the street at a much more rapid clip. Now, we need to pay particular attention to this OCC Federal Reserve settlement. It's a despicable disgrace. It's a kick in the teeth to the American consumer. Think about what happened in the run-up to the announcement of the settlement. All the press was talking about how no consumers were filling out these settlement forms, these requests for reviews and that sort of thing. But in the months leading up to it, we found out that, in fact, at least 500,000 consumers had actually filled out the complaint forms, and that certainly would have provided a good opportunity for regulators, if they cared to document the abuse, the fraud, the lies, the crimes that the banks had committed in their attempts to take back homes from Americans. But more importantly, if regulators in government were involved and actually cared about finding the fraud in the foreclosure process, they needn't wait for consumers to report. All they needed to do was go to courtrooms, ask judges to report on what was happening in courtrooms. They could look here in the state of Florida at the statistics that were being reported by the state of Florida itself, finding that, in fact, hundreds of thousands of cases are still pending in this state, but a significant number, in 2012 at least, had been dismissed by the banks themselves. Now, the question presented by that is, if their paperwork were in order, if they had what they needed and were done correctly and there weren't problems with their files, query me why they were dismissing those cases anyway. Secondarily, if the regulators were interested in finding examples of fraud and the crimes and the other things that were enumerated in the review criteria that they said they were looking for, They could simply go into the Foreclosure law firms and see the documents that were being produced within there. They could interview the employees, the lawyers, the staff workers, the line workers, and they would have a rich source of information about specific crimes that were being committed in the context of foreclosure pursuit cases. What are the crimes? Forgery is a crime. Fraud is a crime. Perjury is a crime. All of these things were being done. Notary abuses were a crime. And all of these things were being done and probably still are being done. So the assertion was being read, of course, that absurd article that was in Forbes magazine, where they asserted that the reason why they shut down the foreclosure reviews, the OCC, was because they couldn't find anything wrong. That was, of course, not true at all. They were shut down because what they were finding are gross examples of systematic fraud and abuses, and they just decided that rather than continue to document the crimes and abuses, they would shut it down and just sweep it underneath the rug. Now, the thing that's most important to keep in mind about this here in the second week in January is that what's going to happen as a result of both of these settlements is the banks and institutions are going to be moving forward with foreclosures at a much more aggressive pace. We've already seen it here in the Tampa Bay area. My survey of new foreclosure filings has been a dramatic uptick since December. I expect to see that all across the state as now they're unloading and filing foreclosures more quickly than ever before. And for those existing foreclosure cases that are pending, particularly here in the state of Florida, approximately 377,000 foreclosure cases that are still stuck in our courtrooms all across the state. The courts are moving much more quickly to move those cases forward. And so you're getting summary judgments that are being set, trials that are being set. A most disturbing aspect of that is these cases are moving forward not always because the plaintiff wants to move them forward, but because the court is taking an initiative and moving those cases forward on their own. Now, I assert that that is an improper position that our courts are placing themselves in. They're placing themselves as advocates for one party in litigation in deciding to unilaterally or sua sponte set cases for progression and set cases for forward movement. Again, I assert that that's grossly improper. It shouldn't be happening, but it's happening all across the state. We need to pay attention to that, and we need to fight back against it. Now, another thing that's buried within all this settlement talk is the fact that part of the money that was being paid by the banks and institutions here in the state of Florida is being used to help consumers. And now, keep in mind, all of the money that was earmarked as part of the 49 state AG thing was supposed to be used to help consumers. But as reported recently, some of the money that's been received is being used to fund the court system that will then progress cases more quickly. And again, what's disturbing about that is moving cases along and setting trials and setting judgments is not a help to consumers. It's a help to the banks and the institutions that cause these problems. And again, my fundamental proposition about all of this is that the banks and institutions caused these problems that both collapsed our economy and then have choked our court system. And our court system, rather than responding appropriately as judges in a court system should do it, say, no, you didn't do it correctly. You failed in your business practices. You failed in your business procedures, and we're not going to make excuses for you. You guys go back and fix what you did wrong and then come back into the courtroom when you can do it correctly. And frankly, it could be done correctly. There are 4 essential documents that are in a foreclosure case: the note, the mortgage, the default letter, and the records of payments due and owing. Now, the problem is those 4 simple documents have been treated so shabbily and so sloppily that the banks and institutions are not able to put them together correctly and do what they need to do in order to properly prosecute a foreclosure case. But rather than holding the banks accountable for their documents and their errors, judges are far too willing to just look the other way and make excuses and allow them to get judgments and trials that they just should not. Just yesterday, I was down in a courtroom watching a disgusting and sad spectacle of foreclosure rocket trials. You know, we've replaced the rocket docket with rocket trials. I watched a very good foreclosure defense attorney make a very good argument, legal argument in defense of his cases and his clients, and just saw them one after the other, objection after objection, just unilaterally being dismissed out of hand by a judge. None of those attention to detail and proper legal procedure that equity and fairness demands Again, the rules of evidence, the rules of procedure, the statutory laws that exist, if these rules and laws were being applied fairly, honestly, and evenly as they exist on our books, the banks would not be entitled to foreclosure. But what you see far too often, and what we saw on dramatic display down recently, was the court ignoring all those things, ignoring rules of procedure, ignoring rules of evidence, ignoring the existing law in order to help the banks get foreclosure. And you can only expect the reason for this is there is a perception among members of the judiciary that this is what is required on some sort of larger societal basis. In my mind, that proposition, helping the banks do wrong, fails the basic analysis and fails the larger proposition that our courts have an obligation to follow the law, to support the Constitution, and follow those basic policies, procedures, practices, rules of evidence, rules of procedure, and statutory law that exist not just in foreclosure courtrooms but across the board. Because if we continue in this condition that we are in now, where courts are looking the other way in excusing banks and their mess in that they created, then what's next? Are we going to allow this to occur in the context of criminal law? Are we going to allow this to occur in the context of family law? Well, clearly that's where we're heading, where we see a dramatic destruction, desecration of the court system, of our rule of law that really lied at the heart of this country. The foundation was a country that was based on a system of laws, and that's just not the case anymore. We're seeing this dramatically every day all around us, where the rule of law is being broken down, none, in my estimation, more clear than what's happening in foreclosure courtrooms. So the message to consumers out there all across the country, and particularly in the state of Florida, is that you've lived in a false sense of security over the last couple of years, where if you've been in foreclosure, you haven't been under any real threat of losing your home because the banks and institutions have slowed things down. Now what's occurring is they're moving much more quickly, and as a result of that, we need to think more quickly. You need to be very specific about getting foreclosure defense attorneys to effectively prosecute your cases in courtrooms all across the country.